one of our commentators for the morning, first morning session isn't here yet. I hope this is not a symptom of Friday the 13th. I thought maybe I could start late and just certify that we had started on time, and then I figured that with an officer of the SEC that might not be such a hot idea. So I actually made me wonder if if the government investigated what I had done, and I'm representing myself as a lawyer, and they want me to waive the attorney-client privilege. Does that mean I'm also waiving the right of against self-incrimination? I don't know. Maybe that will an issue that will come up in the program today. Welcome to the George A. Leet Business Symposium. The symposium was endowed by a generous gift from George A. Leet, a 1946 graduate of our law school. A dedicated supporter of the university for many years, Mr. Leet spent almost his entire career with the National Labor Relations Board, ultimately serving as Senior Associate Executive Secretary. His abiding interest in business law is manifested in this symposium series, which is held in alternate years. The Leet Symposium adds luster to our school by bringing national leaders in law, business, government, and academia to discuss challenging and critical issues in the field. George Leet passed away last year, but his legacy lives on in this symposium, and I think he would be proud of how that legacy is being served today with a colloquy on the most important and controversial issue in business law right now. The corporate scandals at Enron, Tyco, WorldCom, etc. a few years ago prompted agonized questions about what went wrong and how such catastrophes could be avoided in the future. One of the most poignant questions was, where were the lawyers? Each of these fiascos seems to have involved serious violations of the law. Already they have led to several criminal convictions of corporate officers, but in none of those cases did the lawyers step in to avert a disaster. Perhaps it's unfair to indict business lawyers generally over these incidents. Lawyers generally don't know about illegal client conduct. Clients usually hide their misdeeds, especially from lawyers. And even if a lawyer knows of or suspects illegality, it may be unnecessary or inappropriate for the lawyer to divulge that information to the outside world. And even if the lawyers in these cases did not perform as we would wish, it does not necessarily follow that we should radically alter time-honored principles of professional responsibility. It's not surprising, though, that public outcry has triggered efforts that are still underway to transform the role of corporate lawyers. Congress adopted the Sarbanes-Oxley Act, including Section 307, which imposed new requirements on lawyers who learn of illegal acts within a corporate client. The Act also includes Section 602, which provides statutory support for SEC Rule 102E, under which the Commission can discipline lawyers who violate or aid and abet a violation of the federal securities laws. Although the text of Rule 102E has not changed radically in many years, SEC enforcement actions under the rule have mushroomed. There is also concern that, without changing the language of the rule, the SEC has altered its enforcement program and now, under Rule 102E, pursues attorneys allegedly guilty of nothing worse than negligence. Private damage actions against lawyers seem also to have increased. There is a proposal to revise the federal sentencing guidelines to make waiver of these privileges a factor in mitigating the penalty for a criminal conviction. The Justice Department and the SEC now seem to consider waiver of these privileges a factor in deciding whether to prosecute or bring an enforcement action against a corporation. At the same time, there's a proposal to amend Rule 502 of the Federal Rules of Evidence to provide that voluntary disclosure to a government agency during an investigation by it does not waive the attorney-client privilege or work product generally. Ostensibly, this amendment would strengthen the privileges by changing the traditional rule that a waiver to anyone is a waiver to the whole world. However, many practitioners see this proposal as a further step in the evolution of a culture of waiver, in which the waiver of the privileges, which was traditionally made only in exceptional circumstances, would become routine. Behind all these specific issues is the ultimate question, to whom does the corporate lawyer owe allegiance? Is it the client, the entity, the corporation? Or is it to something broader and more abstract, like the public interest? It is sometimes argued that the public corporation, because it is public, should not be treated the same as an individual or private business. In many ways, this principle has gained general acceptance. We now expect public companies to disclose material information, a practice unthinkable 75 years ago. We now hear arguments that lawyers should be viewed as independent gatekeepers, not as hired guns or, more politely, confidential advisors. Is that where we are, or should be headed? Part of this broader question is the issue of who defines the interests of the corporate client. If, as is happening more often, an insurgent shareholder or group elect a minority of directors who request information from the company's lawyer, must the lawyer obey? So I think George Leet should be pleased that this symposium is tackling such an important and timely topic. And he must be ecstatic about the quality of the speakers assembled today for that purpose. Now, admittedly, I put this program together, so in praising the group, I'm tooting my own horn. But in this case, I feel quite safe in bragging that the results of my own efforts are outstanding. We have 4 participants from academia, 1 from the SEC, and 4 from private practice, 2 of those with firms and 2 with house counsel. I will introduce each at the start of the panel on which he or she will speak, but I will say overall that, although I don't want to disparage anyone who is not here, we have assembled the creme de la creme. We have 3 panels of 90 minutes each. I've asked the main speakers to talk for about 35 minutes and the commentators to speak for about 15 minutes each. With a few minutes for introductions and such, that should leave us about 20 minutes in each session for further colloquy among the panelists and audience comments and questions. I look forward to this part of the program because in the past we have had lots of bright, experienced attendees who added immeasurably to the discussion. I've not tried to give the main speakers assigned topics, but have specifically asked them to discuss whatever they think is important and interesting. Similarly, although I have told the commentators that it would be nice if their remarks bear some relation to those of the main presentation, I do not expect or want them to give a point-by-point reply to the main speaker. They're an excellent group, and again, I think we're better off if we have them address whatever they think is most important and interesting. The main speaker on our first panel is Richard Humes, Associate General Counsel of the Securities and Exchange Commission. Mr. Humes represents the SEC in district court, appellate, and administrative litigation. He joined the commission in 1977. He was away for 2 years serving as special assistant to the U.S. Attorney for the District of Columbia, rejoined the SEC in 1980, and has been there since in a number of positions of increasing importance. He has his bachelor's degree from Brown University and a J.D. cum laude from Howard University School of Law. I'll also mention now, so that I don't have to interrupt the flow of the discussion when it's time for the commentators, that we have 2 commentators, and actually we haven't figured out. I guess we'll sneak off into a corner and flip a coin or something. I don't know which one is supposed to go first, but we'll work that out one way or another. One of our commentators is Geralyn Presti, Senior Vice President, General Counsel, Assistant Secretary for Forest City Enterprises. I appreciate that she made the effort to get here. I know she's been running around with what is a pair of $250 million financings in the last couple of days, but I know she wanted to participate in this symposium. It deals with issues that she feels very strongly about, so I'm glad she was able to make it. She received her Bachelor of Music degree in music therapy from Ohio University and worked as a registered music therapist across the street at the Cleveland Music School Settlement for 5 years. Before, I don't know whether she saw the light or fell off the wagon, how you would describe it, but she went to graduate and law school and got a joint MSSA and JD degree from the Mandel School of Applied Social Sciences and our School of Law, where she was also a member of the Law Review. And incidentally, she has been an enthusiastic friend of the school since. She is on the Board of Trustees of the LLM program in U.S. and Global Studies, the Dean's Advisory Council, in addition to serving in many other capacities for nonprofit agencies in the organizations in the Cleveland area. Our second commentator is Bob Rapp, member of the firm of Calfee, Halter, and Griswold, where he is involved in securities and futures litigation and related dispute resolution activities. He is also on the NASDAQ Stock Market Inc. Market Operations Review Committee, a member of the Ohio Division of Securities Enforcement, and an arbitrator for NASD dispute resolution. Mr. Rapp is also an alumnus of the school. He received his bachelor's degree here in 1969, and I think it was made clear last night that was not from Case or Case Western. It was from Western Reserve College. Is that correct? And his law degree from Case. He also obtained a Master of Business Administration from Cleveland State University. Well, okay, then we will get started now. Again, our first main speaker is Richard Humes. Richard. Now, by the way, the commentators, this would be a good time. Yes, why don't we come up here? Richard, you may either sit here or use the lectern, I believe. Is that correct? I think I'll sit.
Good morning. I am obligated to advise you as a member of the staff of the SEC that the views I express today are my own and not necessarily those of the Commission, any commissioner, or my colleagues at the Commission. I'm going to focus today on several significant current ethical issues confronting attorneys practicing before the Commission. I should warn you that I approach these issues from the perspective of a regulator, and so there's a distinct possibility that those of you who have a SEC practice might approach these issues from a different vantage point. But in view of the significant public interest in detecting and preventing securities fraud, I think that both regulators and practitioners share an interest in ensuring that attorneys observe at least minimum ethical standards in their practice before the Commission. First, I will address the types of recent cases the Commission has brought against attorneys. Second, I will bring you up to date on the status of the Commission's up-the-ladder reporting rule that was promulgated under Section 307 of Sarbanes-Oxley, including the issues faced by in-house counsel who report evidence of a possible violation up the ladder and then are fired by their company and bring whistleblower claims under Section 806 of Sarbanes-Oxley. Third, what are the ethical considerations for attorneys representing issuers who want to share work product or attorney-client materials with the Commission pursuant to a confidentiality agreement? And the related question of whether the proposed new Rule 502 of the Federal Rules of Evidence, if adopted, will assuage those concerns. Let me start with proceedings under Rule 102E. Under that rule, the Commission may bring professional disciplinary proceedings against an attorney found to be lacking in character, to have engaged in unethical or improper professional conduct, or to have willfully violated or willfully aided and abetted violations of the federal securities laws, and under Rule 203.7 of the Commission's rules relating to formal investigative proceedings, the officer conducting an investigation may refer to the Commission any instances where counsel had been guilty of dilatory, obstructionist, or contumacious conduct during the course of an inquiry. When an attorney has been found to have engaged in such conduct, he may be sanctioned under Rule 102E. Those sanctions include censures and temporary and permanent suspensions of the privilege of appearing before the Commission. Of course, those attorneys who commit substantive violations of the securities laws are also subject to injunctive actions and cease and desist proceedings. Further, as I will discuss in more detail later, under the Commission's up-the-ladder reporting rule, an attorney may be subject to discipline for failing to report evidence of a material violation within the company that the attorney represents. A general counsel, in turn, may be subject to discipline for failing to follow through on a report by conducting an inquiry or providing an appropriate response. As there are several contexts in which the professional misconduct of an attorney may put him on the Commission's radar screen, different remedies are needed to address the different concerns raised by these contexts. Injunctive and ancillary relief, as well as cease and desist orders, are necessary to stop a violation and, where appropriate, to make investors whole. In contrast, any sanction under Rule 102E is designed to protect the Commission and its processes by preventing lawyers who have engaged in unethical conduct from practicing before the agency. The Commission would not be fully protecting the investing public or its processes were it's simply to stop illegal conduct, but to permit the lawyer to continue to practice for the agency where he can do more harm to investors. In recent years, my office has received referrals of allegations of professional misconduct by attorneys appearing before the agency, but it was not always that way. As we all know, there has been a fundamental attitudinal shift in the way prosecutors and regulators have approached the significant increase in the incidence of white-collar offenses and the lawyers who facilitate or engage in such conduct. Fortunately, from a programmatic standpoint, the Commission seems to be picking up where it left off in 1981 following its decision in the Carter and Johnson case. In that decision, the Commission reversed an initial decision by a Commission administrative law judge that concluded that two attorneys had aided and abetted their clients' violations of the federal securities laws by failing to correct misstatements contained in a client's press releases and commission filings concerning earnings. The commission concluded that existing ethics standards governing the conduct of attorneys did not unambiguously prescribe the behavior in question. Thus, the commission announced that in the future it would interpret Rule 102E to require an attorney who learns that a client is not satisfying its disclosure obligations to take prompt action to end the client's noncompliance to avoid violating professional standards. The commission indicated that what is required is some prompt action that leads to the conclusion that the lawyer is engaged in efforts to correct the underlying problem rather than having capitulated to the desires of a strong-willed but misguided client. The commission announced in its decision in Carter and Johnson that it would solicit public comments regarding whether the newly articulated interpretation of the term unethical or improper professional conduct should be expanded or modified to provide clarity so that attorneys would know what their professional obligations are in these circumstances. However, the commission's announcement engendered strong opposition from the private bar, which argued that the commission did not have express statutory authority to either promulgate Rule 102E, regulate attorneys, or to sanction attorneys appearing before it who engage in professional misconduct, and should leave such issues to the state bars. In the end, the commission never amended Rule 102E to reflect its decision in Carter and Johnson as to what constitutes unethical or improper professional conduct. Further, the commission's then General Counsel expressed concern in a speech regarding the commission's lack of either the time or expertise to fashion a code of professional conduct for attorneys appearing before it. He further suggested that the commission should focus its attention on bringing Rule 102E proceedings against attorneys when the alleged misconduct represents a violation of established state law ethical or professional misconduct rules and has a direct impact on the commission's internal processes. He also indicated that the commission should generally not institute Rule 102E proceedings against attorneys absent a judicial determination that the lawyer has violated the securities laws. Consequently, between 1981 and 2002, while the commission brought actions against attorneys, it did not adopt a comprehensive set of standards of professional conduct for attorneys. As we all know, this landscape changed dramatically with the enactment of Sarbanes-Oxley. The act not only directed the commission to promulgate the up-the-ladder reporting requirements, but also expressly authorized the commission to promulgate minimum ethical standards for attorneys appearing before the agency in the representation of issuers. Further, in Section 602 of SOX, Congress amended Section 4C of the Exchange Act by specifically adopting the language of Rule 102E, authorizing the commission to discipline attorneys appearing before it who engage in unethical or improper professional conduct. In my view, Congress, in granting the commission such broad authority, intended to empower the commission to address comprehensively professional misconduct by attorneys appearing before the agency. Thus, the commission can now reach conduct that violates substantive provisions of the securities laws, current commission regulations regarding professional conduct, and any additional ethical standards the commission determines in the future to promulgate under the authority granted by SOX. And some have argued that the SEC should not take on the responsibility for enforcing ethics rules, even when the violation occurs in connection with practice before the agency, because that should be done by the state bar associations. They also argue that the SEC does not have the expertise to interpret or apply ethics provisions. A violation of an ethics rule during an SEC proceeding has the potential to cause significant adverse effect on the outcome of the proceeding and the commission's processes. While the commission has delegated authority to its ethics council to refer this type of misconduct to state bars for their consideration, discipline imposed by the state bar will not necessarily address the commission's principal concern with protecting its processes from unethical attorneys. Further, any sanction imposed by the state bar likely would not include action that protects investors by, for example, suspending the attorney's privilege of appearing before the commission. But the question about the commission's expertise in these matters is a legitimate one. Since the enactment of SOX and its mandate to promulgate standards of professional conduct for attorneys, we have been working diligently to develop that expertise to address our newfound responsibilities in this area. Authority to investigate and prosecute ethics violations by attorneys continues to reside in the Office of the General Counsel. This reflects the consideration that the authority to pursue proceedings involving allegations of professional misconduct should not be viewed as augmenting the Division of Enforcement's mandate to investigate securities violations. While those of us at the Commission are confident that the Division would not use any responsibility to enforce ethical standards as a basis to obtain leverage against lawyers in pursuing and settling its cases, to avoid even the perception that this is the case, the authority in this area rests with the General Counsel. Accordingly, we have created a new unit in the office, headed by an Assistant General Counsel, to handle these matters. Of course, any formal investigation or order instituting proceeding against an attorney must still be approved by the Commission. In conducting our inquiries, we provide the same rights and procedures as the Division of Enforcement provides in conducting its inquiries. Indeed, earlier this year, the Commission issued a rule that authorizes the Office of General Counsel to conduct preliminary inquiries without a formal order so that immaterial allegations of attorney misconduct can be examined without a formal order of investigation. While we have to do our job and conduct thorough investigations, we are sensitive to the fact that our inquiries can have a palpable effect on an attorney's professional reputation and livelihood. This concern reminds me of the statement of the Christopher Plummer character in the movie Syriana, who said, "You are innocent until you are investigated." Those of us at the Commission working on these cases adhere to a different notion. You are innocent until we can prove a violation. In discharging our responsibilities in this area, we are very mindful of the fact that any actions we take may be interpreted by the private bar and their clients as designed to chill zealous advocacy by counsel in investigations and administrative proceedings. I can assure you, however, that is not our goal. We are not focusing on creative but non-frivolous legal arguments, on reasonable contentions as to the facts, or an innocent error in legal judgment by an attorney that does not threaten the Commission's processes or investors. Instead, we are concentrating on cases where an attorney appears to have engaged in intentional or at least reckless misconduct that also violates substantive or ethical obligations to which the attorney is subject. A brief review of the recent cases the Commission has brought against attorneys bears this out. Earlier this year in re Dale Rasmussen, the Commission imposed a 3-year suspension under Rule 102E against a former senior counsel at Enron for his role in a scheme to improperly accelerate the recognition of revenue from the sale of a construction contract, which resulted in Enron filing a false 10K. In re James Brown, the Commission imposed a 5-year suspension under Rule 102E against Brown, the former general counsel of Management Systems Corporation, where he reviewed financial statements filed with the Commission that materially misstated results of operations. In addition, he was responsible for providing the company's auditors with inaccurate information. Similarly, in recent cease and desist proceedings against attorneys, the cases involved professional misconduct that threatened investors. In re David Drummond, the Commission entered a C&D order against Drummond, the general counsel of Google, for permitting Google to issue unregistered securities under its stock option plan. And in re John Isselman, the Commission entered a C&D against the former general counsel of Electro-Scientific Industries for failing to provide important information to the company's audit committee, board of directors, and auditors regarding a transaction that enabled the company to report a profit instead of a loss. While I cannot comment publicly on the details of cases we are currently investigating, we would be interested in allegations of professional misconduct that involve obstructing our proceedings, such as attempting to suborn perjury, falsely certifying that document productions are complete, altering documents provided to the agency, or withholding documents that are responsive to agency subpoenas. One additional point in this area that may give some comfort: even where the Commission has imposed a suspension under Rule 102E, there is usually an opportunity for re-entry upon a showing that the attorney has fully complied with the Commission's order and has not engaged in any other conduct in the meantime that would bear on his fitness to resume practicing. let me bring you up to date on the current status of the Section 307 rules and what lawyers who are whistleblowers are experiencing. Excuse me. In Section 307 of SOX, Congress directed the Commission to promulgate a rule requiring an attorney for an issuer to report evidence of a material violation up the corporate ladder to the chief legal officer or to the audit committee or another committee of the board until he obtains an appropriate response. Our final rule became effective in August of 2003. The Commission did not at that time resolve the more prickly issue of whether to require attorneys to withdraw and report evidence of a violation to the Commission in the event the issuer does not provide an appropriate response. Instead, the Commission asked for further public comment on alternative proposals on whether it should promulgate a mandatory reporting out rule. The first alternative was to require reporting out by retained counsel where the violations are ongoing and to have permissive reporting out as to past violations. The second alternative was the so-called 8K approach. That is, when an attorney has reported a violation and has not received an appropriate response, to have the issuer file an 8K disclosing that its counsel has withdrawn for professional reasons. The rationale for this alternative was that it should assuage the concerns of attorneys that even the reporting to the Commission of a withdrawal would be deemed a violation of the attorney-client privilege. The Commission received numerous comments on these proposals. As one would predict, most attorneys in private practice and bar groups argued against the reporting out, while most academics and groups representing investors urged that we adopt such a rule. To date, the Commission has not taken final action on the proposal, and no meeting to do so has been scheduled. In the meantime, we can observe how effective the existing rules are in getting the evidence to the appropriate corporate officials and whether these officials are acting responsibly. To date, the Commission has not brought any enforcement actions under its Section 307 rules. And I don't find that particularly surprising, as we never thought that once the rules became effective, we would start looking solely at conduct by attorneys that might be problematic. Instead, we thought we would only see a Section 307 case after enforcement conducted an investigation and found corporate misconduct, and at the end said, did the lawyers know about this, and if they did, what actions did they take? Personally, I would be perfectly satisfied if the Commission never had occasion to bring a case under the Section 307 rules. To the extent our rules can be viewed as nudging the corporate culture in the direction of expecting and encouraging employees to report potential violations, then the rule will have been effective even in the absence of any proceeding against an individual attorney. There's considerable evidence that this is occurring. Issuers have put in place internal reporting requirements that are at least as stringent as those in our Section 307 rules, and they generally apply to all employees, not just to attorneys. Further, most law firms with a significant SEC practice have also put in place procedures to address their obligations under the rules. There is also anecdotal evidence that the rules are working. I and my colleagues at the Commission have been advised that attorneys have reported situations where they have had difficulty convincing clients to make disclosures they believe are required by the securities laws, but when they advised the clients they had to discuss with their other partners and upper management their obligations under the Section 307 rules, the clients agreed to make the disclosures. One issue that arose when the rule became effective was whether it preempted inconsistent state ethics rules. There are a number of states that have rules that would prohibit an attorney from making a permissive report to the Commission of an ongoing violation as permitted under our rules. Washington State has such a rule, and the Washington State Bar was considering amending its rules to provide specifically that attorneys should not comply with our rules. In their view, because our rules permit the reporting out of ongoing violations, and Washington's rules prohibit it, there was no conflict because the attorney can elect not to report out. In response, the Commission's General Counsel wrote a letter that is posted on our website stating that our rules preempt Washington's rules because Supreme Court precedent establishes that where a state rule prohibits what a federal rule permits, the state rule is preempted because it would interfere with the discretion provided under the federal regime. Similarly, the state of California contacted us and asked us not to enforce our rule as to California attorneys because compliance could put them in jeopardy of being subject to discipline by California authorities. We responded that any jeopardy was being created by California threatening its attorneys if they complied with our rules. We urged them to stand down, as our rule was presumptively valid and theirs presumptively preempted. Eventually, California put out an alert advising lawyers not to comply with our rules without expert legal guidance. On the other hand, North Carolina recently announced that it deemed its ethics rules preempted by the Part 307 rules on the issue of permissive reporting out. It seems to me the preemption rule has been resolved by court decisions over the past several years, which established that inconsistent state rules are preempted. In particular, in Jevony versus Superior Court, the California Supreme Court held that state arbitration rules were preempted by SEC-approved NASD rules because, one, the SEC had the statutory authority to approve those rules, and two, and I think this is most important, although it was not impossible to comply with both sets of rules, attempts to comply with both would impede compliance with the SEC-approved rules, and that would impede compliance with the SEC-approved rules. There have been similar decisions on this issue in other cases, and they have agreed with our view. And although these cases are not 100% on point, I think the case for preemption is even stronger as to the Section 307 rules, as they were specifically mandated by Congress. Another ethical dilemma for attorneys arises as a result of the intersection of the Section 307 rules and Section 806 of Sarbanes-Oxley, which provides whistleblower protections for persons, including lawyers, who report evidence of violations within an issuer. Section 806 makes it illegal for an issuer to discriminate against an employee in the terms and conditions of employment in retaliation for lawfully providing information to Congress, the SEC, or any supervisor that the employee reasonably believes constitutes a violation of any SEC rule relating to fraud against shareholders. An issuer that violates this provision is subject to civil and criminal sanctions. SOX places responsibility for administering these proceedings in the Secretary of Labor. The SOX whistleblower protections are critical for an attorney who may report a violation by his issuer or client, but fears that reporting the violation will expose him to retaliation, including the possible loss of his job. But any attorney who makes a report under the Section 307 rules runs the risk that, in any proceeding challenging any retaliation in which the attorney seeks to use his report and/or the client's response, the attorney will be accused of improperly disclosing client confidences, thereby exposing him to charges that he has violated state ethics rules. The attorney also runs the risk that his report and management's responses, perhaps the best evidence of his whistleblowing activity, will be excluded as privileged. This squarely raises the issue of the scope of the permissible use in SOX whistleblower litigation of a Section 307 report by an attorney. Clearly, if attorneys who comply with our rules cannot introduce evidence of their compliance, then Section 806 will be rendered a nullity as far as lawyers are concerned. In a number of the Section 806 cases that are pending before labor, we have seen threats by former employers against lawyers if they use their reports in the proceeding. Fortunately, Section 205.3D1 of our Section 307 rules expressly provides that any report or response thereto, quote, may be used by an attorney in connection with any investigation, proceeding, or litigation in which the attorney's compliance with this part is an issue. At least one court decision has reached this precise issue and concluded that an attorney may use client confidences in these proceedings. In Willie versus Arbitration Review Board, the Fifth Circuit correctly started its analysis by concluding that federal law would govern the issue and not state ethics rules. It concluded that the model rules specifically provide that a lawyer may reveal information relating to a representation to the extent the lawyer believes necessary to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. And the Section 806 proceeding was the type of dispute between a lawyer and client contemplated by the model rules. While the report really predated our Rule 205.3 and thus did not cite our rule, that rule is just the kind of federal law that the Fifth Circuit was referring to as controlling its analysis. Thus, we are cautiously optimistic that going forward, attorneys will not be hindered in establishing Section 806 cases by claims that in doing so, they are improperly disclosing client confidences. However, it still remains to be seen whether really will be followed in whistleblower cases that arise in jurisdictions outside the Fifth Circuit. We know that the issue has been raised in a number of other cases, and we are monitoring them for possible amicus participation by the Commission. Moving on to confidentiality agreements to protect the work product and the proposed Rule 502 of the Federal Rules of Evidence. For a number of years, issuers under investigation have provided materials to the Commission staff pursuant to confidentiality agreements, which provide that the issuer is not waiving privileges for the information, and the Commission agrees that it will not contend the production constitutes a waiver of any applicable privileges as to third parties and as to additional documents not produced. The materials that have been of the most interest and benefit to the Commission are internal reports prepared by retained attorneys for issuers examining problems with financial reporting. These reports usually fall within the scope of the work product doctrine and often include memoranda or attorney interviews with company employees. The reports may also reflect communications protected by the attorney-client privilege. The Commission has argued in a number of amicus briefs that state and federal courts should find that companies under investigation by the SEC do not waive work product protection as to third parties by disclosing such internal reports to the Commission pursuant to a confidentiality agreement. The Commission has taken this position because allowing companies under investigation to produce privileged information without waiving privileges serves the public interest as it significantly enhances the Commission's ability to conduct expeditious investigations and to obtain relief for defrauded investors. Although the Commission must verify that these internal reports are accurate and complete and must conduct its own independent investigation, doing so is far less time-consuming and less difficult than conducting investigations without the internal reports. Even the majority opinion in the Columbia HCA decision from the Sixth Circuit, which declined to recognize such an agreement and instead found a waiver, acknowledged that permitting companies to disclose privileged information to government investigators results in, quote, considerable savings in time and fiscal expenditure, close quote, and encourages both self-policing by companies and settlement of disputes. However, the government has enjoyed only limited success in convincing the courts to recognize these agreements. The courts that have accepted them have done so primarily because they believe it is in the public interest for companies to be able to share privileged information with the government without waiving privileges as to third parties. Those courts that have rejected them have done so primarily because they cannot reconcile allowing a company under investigation to reveal work product to a potential adversary, that is the government, with the historical purpose of the work product doctrine to keep an attorney's trial preparation materials out of the hands of its adversary. The Tenth Circuit's recent decision in the Quest case has cast further doubt on the viability of these confidentiality agreements. In Re Quest, the district court presiding over private action against Quest declined to give effect to an agreement between DOJ and Quest covering a report of potential corporate wrongdoing prepared by its retained counsel because it found that Quest had waived work product and attorney-client protections by sharing the documents with the government. The Tenth Circuit affirmed, rejecting the argument that if courts do not recognize such agreements, that companies will cease cooperating with law enforcement officials absent protection under the selective waiver doctrine. It noted that Quest had disclosed to the government 220,000 pages of protected materials, knowing that the private action was pending against it, and in the face of what it saw as almost unanimous circuit court rejection of the selective waiver doctrine, and in the absence of any Tenth Circuit precedent to support it. These developments raise at least two distinct issues for securities lawyers. One, can lawyers tell their corporate clients in good faith that they should execute these confidentiality agreements with any realistic expectation that they will be given effect by a court presiding over a private action against the company in which the internal report is sought. And two, assuming there is a basis for companies to continue to enter into these agreements, should the companies and the bar resist entering into these agreements because they undermine the attorney-client privilege? As to the first issue, it is worth noting that the United States District Court handling the class action against McKesson recently adopted one of these agreements. Now, while a lawyer would have an obligation to advise his client as to the state of the law in any particular district court or circuit, there has been no definitive judicial decision rejecting such agreements. Besides, as the 10th Circuit recognized in Quest, these cases are fact-specific. The Quest Court noted repeatedly that it was deciding the case on the basis of the record before it and seemed to be particularly skeptical of Quest's arguments because the agreement was entered into when Quest was already in private litigation concerning the same subject matter and thus knew the documents were likely to be subpoenaed and the risk of a finding of a waiver, therefore, substantial. Under different circumstances, such as where there was no pending private action at the time of the agreement, or if there is a pending action but it is not in a jurisdiction where there is support for the doctrine, then the outcome may well be different. Further, several of the courts addressing these issues have appropriately distinguished between requests for attorney-client materials and those seeking work product. It is universally recognized that sharing attorney-client materials with a potential adversary waives the privilege. On the other hand, there are a number of situations where potential adversaries may share work product without waiving the protection, such as when parties have a common interest or a joint defense agreement. While the Commission has not maintained in its amicus briefs that it has a common interest with those persons it investigates, corporate parties to these agreements have made such arguments. In April of this year, the Commission provided to the Advisory Committee on the Federal Rules of Evidence testimony on the proposed new Rule 502. That rule, if adopted, would provide that a person under investigation may disclose voluntarily attorney-client and work product materials to federal agencies without waiving privileges, even in the absence of a written confidentiality agreement. On August 10th of this year, the Advisory Committee published for comment a revised version of the proposed rule that would provide these protections and specifically invites public comment on whether the proposed rule would promote cooperation with the government and decrease the cost of government investigations and prosecutions. The comment period runs until February 15th of 2007. There is opposition to this rule from the private bar, which has expressed concern that since the mid-1990s, the principal government law enforcement agencies have developed policies and guidelines that are designed to induce corporations and other business entities to waive or not assert privileges, and the result has been a marked increase in the compelled, requested, or suggested voluntary waivers of privileges. In their view, there has emerged a culture of waiver in which government agencies expect a company under investigation to waive privileges, and many companies now do so without even being asked, believing there is no practical alternative. But the Commission has concentrated its efforts on obtaining reports prepared by retained counsel after the discovery of potentially fraudulent conduct, where those reports are prepared at the behest of the Board of Directors or the Audit Committee with full knowledge that they are likely to be shared with the SEC. While an issuer may make the determination that it is in the entity's best interest to produce the record of contemporaneously provided legal advice, such as when the privileged communications were with former management that may have engaged in misconduct and have been ousted, that is not a waiver that the Commission staff has generally sought. Second, the bar is concerned that with respect to the internal reports that are of interest to the staff, companies no longer have the predictable protections of confidentiality because realistically, they do not have the option to maintain privileges without being viewed as uncooperative. But this position ignores the fact that current management may appropriately determine to disclose privileged evidence of misconduct by prior management because it is in the best interest of the entity. And even where the privileged evidence of misconduct may concern present management, it may still be in the best interest of the entity to disclose this information because it may show self-policing and address the concerns of investors, shareholders, and the commission about possible management misconduct. The company may appropriately put the entity's best interest ahead of those of a current officer who may be guilty of misconduct and would prefer the entity to assert the privilege to protect his own personal interests. Thank you for sharing your time with me.
Thank you, Richard. I learned at dinner last night that Richard's a baseball fan, as I am, and we both know and he's rooting for the Tigers in the current baseball playoffs, and so we appreciate the importance of having a good leadoff hitter. I think you did a great job as the leadoff hitter here. I'm not entirely sure that you've put all the concerns at rest, but we'll see that. Okay. Well, yeah, I was actually I mentioned that Jerry Presti has her first degree in music therapy. Was that music to your ears, Jerry? Did that have a therapeutic effect?
Yes, it did. Thank you very
Good.
much. Thank you. It's a pleasure to be here this morning among such distinguished company, and also to have the opportunity to share with you my experience as being general counsel of a public company and what the last 4+ years has been with trying to comply with Sarbanes-Oxley and the New York Stock Exchange rules. And actually, there is a thread. It's not so schizophrenic, my piano and behavior therapy, music therapy career in Sarbanes-Oxley, Richard, because we reinforced positive behavior and had consequences for negative behavior. And I see that thread, common thread here. You know, as I read over Richard's proposed remarks today, it helped me recall a quote that was quite on point, and it's by Haile Selassie. And the quote is, "Throughout history, it has been the inaction of those who could have acted, the indifference of those who should have known better, and the silence of the voice of justice when it mattered most that has made it possible for evil to triumph." I became general counsel of Forest City. I had been there about 13 years and had started as corporate counsel and advanced to deputy general counsel and stepped into the office of general counsel that very same month that Sarbanes-Oxley was enacted. Bill Warren, the former general counsel, had been there for 50 years, and it was quite an appropriate time for him to pass the baton to me. So I not only had the challenge of learning how to become general counsel of a public company, but also to the challenges of meeting these requirements and the plethora of laws that were proposed and subsequently enacted. Just for those of you who don't know, Forest City Enterprises is a publicly traded company on the New York Stock Exchange. It was founded in 1920. It became public in 1960. We have two classes of shares that are traded. We're an $8 billion real estate company. We're headquartered here in Cleveland. We have 8 offices throughout the country and several strategic business units, but we're a real estate development company. I have to say that, being in-house counsel and being general counsel, I feel, and Bob can disagree with me, that we're closer to the business. I mean, we are counsel planted right in the middle of the business. And I always felt that I had a gatekeeper role even before Sarbanes-Oxley. I mean, we were in charge of the regulatory compliance, our bank covenants. We have a revolving credit line, $600 million now, but keeping those covenants in compliance, enforcing the obligations to our partners under partnership agreements, the obligations under our leases to tenants, and so forth. So I've always viewed us as the watchdog of the corporation. But clearly when Sarbanes-Oxley came into being, this role was even dramatically and significantly increased. And I feel the great mantle of responsibility as well as the potential liability. I have to say that there were a lot of changes that came, and these were positive things and good things. Just the effort to comply. We had a code of ethics, but I think it was distributed when people came into the corporation, and it was never looked at again or discussed or trained upon. We had a governance committee, but actually it was pretty inactive, and they hadn't met regularly. We had charters, but we hadn't reviewed them and revised them regularly. And director independence, I agree very much with Richard's remark. It's especially critical for all companies, but especially for us, because we are a controlled company under the New York Stock Exchange rules. So the majority of our insiders of our directors are insiders. We have 5 independent directors. So their role is very, very critical to us. And where initially Sarbanes-Oxley, and maybe still, required that your audit committee be composed of all independent directors, all of our board committees are composed of independent directors. This is something, I've struggled with over the years because the institutional shareholder services, when they rank corporations, we're never going to become into wonderful compliance under their purview because we've got two classes of, capital structure, the A and B structure. The family owns 74%, the majority of the B stock, and they own about 18% of the Class A stock. And also, too, because we are a controlled company. So this is something that ISS doesn't like particularly. The other positive things that have come about is the General Counsel has indeed had increased interactions with the CFO, the board committees. I'm active on all the board committees, the board, the CEO, and I think that this has been a good thing for General Counsels, and it's empowered us. I find that we have more written policies now. We have policies on how and when we review and make charitable contributions to the entities that our independent directors are on, and many more written policies. I get increased questions from my associates, those that have stock, the trading periods. When are the blackout periods? What is the process for getting clearance, and so forth? I'm asking more people that come to me, can they sell stock? I'm asking, well, do you possess inside information? What do you know right now? And I think that we've always had what we call transaction committee, and this is where senior management reviews our financial transactions before we do our quarterly filings with the SEC. But we've added the disclosure committee meetings to that. Those meetings are longer, and there's more transparency and deeper discussion. And sometimes now even our audit committee is involved, and our outside auditors, PricewaterhouseCoopers, and we're able to flesh things out in potential issues, revenue recognition, discontinued operations, and other issues that are important to the auditors. We're able to flesh that out earlier and discuss anything that might be a problem. So again, I think our independent directors' role are critical. They're very concerned about maintaining their independence. I get frequent calls from them. Just recently, one of our independent directors had a son-in-law that was interested in doing business and partnering with the company. But after discussing that it would probably taint his independence, that deal was never pursued, which was appropriate. There's a demand for more information from our board. The audit committee will ask us to go back and research our intercompany accounts and find out, are those reconciled appropriately? So I think that all of this is very good. I think some of our most challenging times came with 404 internal disclosure, internal controls process. This was especially challenging for Forest City because we're highly decentralized. And when it came to tracking how many key controls we had, when we had to do a baseline review, we came up with something like 2,100, which was just outrageous. We finally realized that a number of the controls were duplicated in our various strategic business units. So that brought down the number to 1,100, but still we had a great deal of manual controls. So this was quite a challenge, and we ended up having weekly audit committee meetings on 404. We were just determined we weren't going to fail this and that we were going to pass, and we did very successfully, I'm proud to say. And other things came into being. We had a hotline. We always had a hotline internally, but we got an external hotline where people could feel that they could have an easier time reporting unanimously. It's interesting. Our external hotline's been in place for about 2 years now, and I report quarterly to the audit committee the types of calls that come in and what business unit they affect and all of that. And we've had no calls in the last months. We do publicize it. We'll put it in our newsletter. We'll put it on the website. We'll put it onto paychecks. It's anonymous or not. But I'm pleased to report that we haven't had any complaints or anything material really. And maybe the best thing that's come out of this is we've established a risk management department. We plan to have about 12 people in that department. Initially, the CEO said, well, why can't internal audit or why can't the legal department deal with this? And it's just really appropriate you have another department that reports to the audit committee directly and on a dotted line to me and the CFO. But what this risk manager does now is he handles the 404 compliance. He deals with conflict of interest forms and acknowledgement. He takes care of the fraud surveys and helps our outside auditor do that when they're conducting surveys to ask people if they've been asked to do anything fraudulently. And the federal U.S. sentencing guidelines ask us to do risk assessments. And so that department handles that as well. He trains on the code of ethics, very appropriate. So I see many advantages of compliance with these rules. most of all, I can sleep at night. That's my goal, is I have to be able to go to bed with a clear conscience every night. As I said, I have increased interaction with the senior management and the board and the various committees. There is greater transparency and accountability. And something a common mantra in our corporation is tone at the top. And the audit committee will ask us, what is the tone at the top? The auditors are curious about that. And I have to tell you that I'm very proud and pleased that I think that we do have the right tone at the top. And it's very, very important to set that corporately. And now that I've gotten through all the positive things, I have to tell you that this process we've paid a steep price, and it hasn't been without its immense challenges. Primarily, and I'm sure, Richard, that the SEC, in many comment letters early on, you've probably heard complaints from corporations that this has been incredibly expensive. Our compliance with 404 costs between $8 and $10 million. We hired KPMG as outside auditors to help us with our compliance. And more importantly, it's just been very time intensive. There's been a point when it was really hard to do our day-to-day jobs, all of us, particularly the accountants, because they were so busy trying to comply with the internal controls and procedures that it was just very difficult. We've done a great deal of hiring of accountants. I think it's the Accountant Relief Act now. I used to talk about the Attorney Relief Act, but it's a full employment in our entity for accountants. And the Risk Management Department has incurred additional expense as well. And at times, I have to admit to you, I think about, as general counsel, 75%, 80%, and maybe it's dropped a little bit in the last years. My attention has been on corporate governance, and my CEO has said to me, well, what are you doing about the business? We're in the real estate business, but it has been distracting, maybe appropriately so, but it has taken a great deal of time and effort. And when I think I've caught up, we now have 400 more pages of the securities rules that have come out in terms of proxy and the compensation rules, which I'm now trying to get up to speed on as well. Other types of things that the challenges have been some pushback from our managers. It hasn't made us acquiesce, but we now have our financial people signing representation letters because the CEO and the CFO have to sign certifications every quarter that our internal controls are in place and there's no fraud and so forth. They obviously can't know what goes on throughout all the corporations and the strategic business units. You've got over 4,000 people in the corporation. So we've got these representation letters going on down the line, and there was a great deal of pushback. I'm not so sure that these people were so worried about committing fraud or worried about that aspect as they are about their liability or maybe doing something negligently and worried about being accused of fraud. But we've kept those representations into place. Furthermore, it's made the chairman's groused a couple of times that we now have 15 board resolutions before we can even start our board meetings in March, because we're going through the process of electing our Section 16B company insiders and talking about the financial expertise of our audit committee and the independence of our independent directors and so forth. So it's added time, and it's kind of taken away from some of the business at the board meetings. And I guess the biggest challenge, too, has been is there's been a real change, and Chuck Ratner, the CEO, comments on this. Maybe 20 years ago, you felt kind of like you had a partner relationship with your outside auditors. I mean, it was more of a team kind of spirit, and even with our outside SEC counsel. And to be perfectly frank, even though we've had no restatements, we've had no major issues that we haven't gotten through, sometimes it feels like the relationships are a little bit more adversarial these days. So, and that's been kind of tough too, because we're a family corporation, and relationships are important. I did review some of the cases that Richard spoke about in his talk, and I agree that, when I read about these behaviors that didn't give full disclosure to their board, or they gave distorted information to their audit committees, I mean, frankly, it's egregious behavior, and it should have consequences, and it should be punishable, and I can't imagine doing such a thing. And I guess I'm just really fortunate that I come from a culture where it doesn't motivate everybody, but reputation is very, very important to our founding family members and to the company, and our integrity and the contributions we make to our shareholders, our investors, and the communities. So I guess I'm very, very fortunate for that aspect, and that gives me some comfort. To address the up-the-ladder reporting issue, I have to admit that when this rule came out, it made me a little bit uncomfortable. I thought, oh my goodness, I not only have to go directly to the SEC if I get, upsetting information, but I may lose my job, and I love my job. And it was a bit disconcerting, but I do understand the need for this. And I think that it does empower lawyers, it does empower the general counsel, and it does bring a heightened awareness of the huge responsibility that our financial people and our CFO and controllers, the responsibilities that we bear. I have to say that we do have we follow the law with our whistleblower policies. We do have it in our code of ethics. We make it very clear that if anybody comes forward with sensitive information or allegations of fraud, that there will be no retaliation, and we're very clear about that, and that everybody's trained on that. And I have to say, and it's true, I mean, coming from this behavior music therapy background, it's in classrooms, in corporations, with our children, I think it's really important to communicate clearly expectations. And if you don't have consequences, then it doesn't matter how many rules you have. It's not going to be followed if there are not clear consequences. And I think that the fact that they're at the federal level and with the SEC is absolutely appropriate. I don't know how much you can legislate morality or wrongdoing. And sometimes, with the Enron cases, and when you hear what went on, you just wonder how people could even, begin to engage in this thing. But I think the plethora of rules does a lot to mitigate or to deter potential wrongdoing. And I was honored to be able to speak to the incoming law class here at Case as they had their induction ceremony this year. And as I talked about, my experience at the law school and my experiences being a practicing in-house lawyer for the last 18 years, I talked about with the privilege of being accepted into law school comes this huge mantle of responsibility, of integrity, and of ethics. And I think nowhere, more importantly than now, that ethics law school class is incredibly important these days. And as to who should bear the risk and the burden, I think it is we in-house lawyers. I mean, we are closest to the situation. We are the gatekeepers. And I agree. I mean, to be able to protect the interest of investors and the public, I think we should take on that mantle of responsibility. And finally, I do want to comment where I now I saved it for last, Richard. where I don't entirely agree and where I'm a little bit uncomfortable is around this idea of the selective disclosure and the selective privilege with this attorney-client privilege and attorney work product doctrine. And to be honest, I hadn't thought about this too much more, and I'm glad you brought it to my attention. I think that the attorney-client privilege is the oldest of privileges for confidential communications, common law privilege between an attorney and their client, and I think it's really, really sacred. And again, as you all are aware, the purpose is to encourage full and frank communication from our clients so that we can give proper advice. I mean, I think the worst thing that could happen to me, and I was talking to my CEO, we just came back from leadership meetings in Chicago last night, and we were riding from the airport together, and I was talking about this to him, and I think my biggest fear would be, I am a part of sensitive discussions, and I feel like I really know what's going on within the corporation and throughout it, and the fact that if there's a fear that I might have the ability to disclose to the SEC some privileged communication and that would leave me, then they would put me on the outside more or keep me out of it. I think that would be very distressing for me, and I think it would be, just not a good consequence for the client. So it's important that that I'm able to give the client good legal advice and that I get complete information. I think even if you have a confidentiality agreement, I mean, we do that a lot. In fact, with this new convertible debenture offering we just closed, another deal we just closed, I had to do some selective discussions with outside people, third parties, and we use confidentiality agreements. So I believe in those, but I'm not so sure that the courts are sure that those confidentiality agreements will protect us. And in fact, one court, this is Steinhardt case out there, Steinhardt Partners, said that the confidentiality agreement transforms I love this, the attorney-client privilege, and I quote, another brush on an attorney's palette where we can utilize and manipulate to gain tactical or strategic advantage. That's perhaps one viewpoint, but I worry that I'd lose trust from the client. Reasons I thought about looking at the other side, reasons that an attorney or a company might want to do this, might want to disclose or have a selective waiver to privileged information or work product doctrine. And perhaps to their advantage, they might want to delay prosecution if they feel that the alleged claims are unfounded, and also perhaps to obtain more lenient treatment from prosecution. So that might be an advantage to the corporation. It's interesting, though, in reviewing this Quest case, they argued in its holding that really that the government seeks to establish a new privilege, which I thought was very interesting, too. It's not really just a selective privilege, it's a new privilege. And certainly I just think there's more thought to be given here. The SEC has gotten voluntary cooperation from companies, and it's also possible for the SEC to have other avenues to independently gain access to the same protected documents. They can invoke other accepted exceptions to the rule, which are crime or fraud exceptions to the privilege, and those are already standard. And I guess I would ask the question, and I agree also, Richard, with the Quest case that I think it's very, very fact-related and very specific to the circumstances of the case. I think that a selective waiver would be, you just have to ask if a selective waiver is truly necessary to receive cooperation and to weigh the hardships and the benefits and the burdens. So I'm still not convinced that it's necessary that we need to go that way. I think I still fear that the exception would just totally waive the privilege and it would get into outside third parties' hands. And it was interesting, too, I think it was Justice Boggs that gave the dissenting opinion in the Quest case. And his reasoning, he said, it's not just really clear what the negative consequences would be, what the hardships would be, and I feel that the benefit of disclosing to investors or helping the SEC or the government agency far outweighs that. But actually, I disagree with Judge Boggs because I think because we don't know clearly what all the negative consequences would be, I think it's even more reason not to just plunge ahead and pass Rule 502 and go ahead with it. So thank you very much for your attention today and the chance and opportunity to speak.
I think that offered a very interesting perspective. I think you tossed in a few accidentals, but otherwise were in tune with the basic presentation. Are you going to sing the same tune, Bob, or perhaps offer some counterpoint?
Well, more or less always been accused of singing my own tune, so I'm not sure whether that's a good thing or a bad thing here. But a couple of real quick comments. Jerry, you mentioned the extraordinary cost of Sarbanes-Oxley compliance, and in the Section 404 area, it is incredibly expensive, and one piece of fallout from that is that many small public companies are being driven to go private or to, using their terminology, go dark, if you will, by getting down below the threshold for compliance with these provisions and being subject to the entire corporate reporting scheme. I don't know if that's a good thing or a bad thing, but it's happening. Maybe some of those companies never should have been public in the first place, but nevertheless, it has been fallout, and it's an incredibly difficult challenge for them to meet that expense. But as you say, Jerry, the accountants certainly do love it. One other quick comment, if I will, Jerry, you commenting on a piece of Richard's presentation as well. There are also SEC incentives, if you will, to waive privilege. There's a carrot and stick approach that's involved here. I know I've personally been involved in it. It goes specifically in the corporate investigations area, in that the Commission in some published material has, in effect, said that our enforcement decisions can be influenced or determined by the extent and quickness with which a corporation acts to commence an investigation, to deal internally with issues, and then, of course, in making all that work product available to the Commission, so that there is a not only in the more formalized sentencing guidelines and that sort of those areas, but in the area of simply avoiding, if you will, or hoping to avoid SEC action. Companies are, let's just say, encouraged to undertake these investigations and procedures, and of course, as I say, to make all of that available to the Commission, and it amounts to simply a blanket waiver. We're populated by a lot of Ohio lawyers here this morning, Richard, and I wanted to pick up on one point. You talked about the tension, if you will, between state ethics codes and what may or may not be required under the Rule 205 provisions under Sarbanes-Oxley, effective February 1st of 2007, Ohio will have a new Code of Professional Responsibility in place. It has been adopted substantially, although not entirely, on the ABA Model Code of Professional Responsibility. And as a result of that, there will be a provision in Ohio that says that other law may require that a lawyer disclose information about a client. Now, it doesn't go on to say what that really means. It simply says other law may require, and that can dovetail into what you're talking about under Rule 205. And then it also will say, it does say, that whether another law supersedes the rule is a question beyond the scope of the code and something that must be discussed with the client. Now, also, in terms of up-the-ladder reporting, conforming with the ABA Model Code, the new Ohio Code will include requirements, and it uses the term shall, not may, for reporting when it's necessary in the, quote, best interests of the organization and when it's necessary to enable an organization to address the matter in a timely and appropriate manner. So those are the key aspects of the new Ohio Code that bear on your remarks. You know, been doing this for a long time as outside counsel and as a litigator, and we've always, in kind of collegial terms, we've talked about ourselves as securities lawyers, but now there really is, in effect, a securities bar as a result of Sarbanes-Oxley, because with the Rule 205 provisions, we now have a specialized code of professional responsibility, rather than simply looking to 102E, which talks about engaging in bad conduct and doing things in appearing, representing a client before the commission or a hearing officer. We now have a much more generalized code of professional responsibility that is a sea change, and it all comes as a result of definitions. Because in Section 307 of Sarbanes-Oxley, the key concept is what does it amount? What amounts to appearing and practicing before the commission? Now, you would think that was a simple term, but the definition of appearing and practicing before the commission has now taken on an entirely different character. SEC Rule 205 says that appearing and practicing before the commission for purposes of these rules includes advising, consulting about securities law compliance in regard to or assisting in the preparation of any document that will be a part of a submission to the commission, or in regard to any other matter that the lawyer knows is subject to SEC disclosure requirements. Now, this has nothing to do with standing before the commission and arguing a case or making submissions to the commission on behalf of a client in the context of some administrative proceeding. This is a very, very broad definition of basically practicing law in the securities area, where you are counseling or advising an issuer. This then becomes the premise for requiring, under the rules, for an attorney to undertake, quote unquote, an appropriate response in the face of reported evidence of a material violation when the lawyer doesn't reasonably believe that the issuer has done enough to deal with it, in simple terms. So that is the basis then for the up-the-ladder reporting. Now, the ethical dilemma that corporate and securities lawyers face in that process is obviously that the Rule 205 expressly states that you are authorized to disclose to the SEC client communications, confidential information that would otherwise be privileged. If you, the lawyer, believes that doing that would prevent a fraud on investors or a fraud on the SEC or would stem the threat of serious financial harm to investors. And by the way, you can also use the information to defend your own compliance if that becomes an issue. And under Rule 205 and now in Section 307, as Richard touched on, compliance by the lawyer is expressly addressed. And the lawyer's responsibility under Section 307 and Rule 205 is now a prime subject for enforcement action, administrative action, if the attorney involved in the process doesn't do it right. Now, the whole up-the-ladder reporting or the process is permissive. It's not compulsory. I mean, you don't have to go out and disclose things when you're engaged in this process. And if you put yourself in this process as a lawyer, particularly as an outside lawyer, trying to come to a determination here, well, has there been a material violation? What does that mean? Others are going to disagree with that. How do I come to a conclusion in my own professional judgment that there has been something that I can consider to be a material violation that would trigger my responsibility to make a, quote, appropriate response, unquote? Very, very difficult to do that. And again, it is not a compulsory thing, it's a permissive thing. But if you do it wrong, you are in trouble. Now, Richard talked about the position that Sarbanes-Oxley 307 preempts inconsistent state ethics rules. That's problematic, and I think he's acknowledged that as well, that there are a number of folks out there and states out there that disagree with the view that there is preemption in this picture. The up-the-ladder provisions all relate to disclosing client information within a client organization. And that's fine as far as that goes, but there's nothing that says about revealing it or disclosing it outside the organization. The lawyer that is representing the organization deals with the responsibility within the organization, but going beyond that is something else. And there's the difficulty or the conundrum that you face with state ethics requirements. And you have to ask, as we do, whether this has a chilling effect on clients' willingness to seek effective outside counsel or effective counsel, period, and whether it's something that would cause otherwise effective counsel not to want to be engaged in this process, because it could lead to disclosure when a state code of professional responsibility is contrary. Now, again, in Ohio, we have some help on the way with that, but that is not the case everywhere. And it was not the case prior to the new Ohio Code. Another ethical dilemma in this picture, without regard to disclosure of client confidences, is, and I touched on it briefly a moment ago, and that is understanding what the heck an attorney is expected to know. You know, a lawyer's first line of defense in these cases, and George mentioned it earlier, has simply been, I didn't know. Well, when you look at the definitions that are now in Rule 205, adopted by the Commission under Section 3, or as a result of Section 307, there are terms in there such as credible evidence of a material violation, for example, and a duty to report that comes from that. But there's no guidance about what that means. Credible evidence, well, the prospect of a material violation is more than a mere possibility, but not necessarily more likely than not. Is it evidence somewhere between 5 or 10% chance, but less than 51% chance? These are determinations that the lawyer is now charged with making. One other thing to keep in mind, there's nothing about credible evidence that has to be related to a lawyer's specific representation with that client. It's evidence of a material violation, period. And being engaged for a particular project or a particular engagement of a particular scope or subject. In the course of that, if the lawyer determines or comes across what he or she determines is a material violation, completely unrelated, now there becomes the problem. What to do? Because the rules do not say your responsibility is limited only in the narrow area of your engagement. Determining if there's evidence of a material violation can obviously be extraordinarily difficult, because these are not I know it when I see it situations necessarily. Some new approaches that have been taken by law firms as outside counsel is that there seems to be a sense in the law firms that what you don't go solo on any of this. An individual partner who's in charge of or working on a particular situation with a public client, it now becomes a team approach to making these determinations and judgments. And that is that you will see, for example, that within a law firm there may be a designated Sarbanes-Oxley partner. You may see a committee created for Sarbanes-Oxley compliance within the law firm. It's a resource, a place to go to talk about these issues that may come up and to come up with a collective judgment rather than trying to fly solo on making those judgments. And another thing, in Rule 205 is the attention given to the supervisory attorney and the supervisory attorney-subordinate attorney relationship, and making the supervisory attorney, given under the terms in the rule, responsible for the compliance by a junior or subordinate attorney who is directly involved in the representation. Now, here again, you can't look away, and even if you're not directly involved in the representation and in the engagement, you are potentially responsible for the conduct of all those who are under your supervision, and that's a challenge too. Quickly, a point on the confidentiality agreements, Richard. You mentioned briefly the Columbia HCA case here in the Sixth Circuit. That makes it pretty tough. The Sixth Circuit simply rejected any kind of approach that would allow some kind of selective disclosure. Agreements don't matter. Court, stipulations don't matter. Waiver's a waiver, and it's very difficult to counsel a client in that environment. That there's any reason. You ask about the counseling and advising about, can you be comfortable in expecting some kind of protection, and around here it's very difficult to say that you could be comfortable. Columbia HCA is there, and it's very straightforward. There was a nice dissenting opinion, and Judge Boggs was mentioned, and more often than not when you see Columbia HCA cited today, and it's citing to Judge Boggs' dissenting opinion, which talks about the public interest and the necessity of, in terms of the public interest, to permit some kind of or recognition of some kind of selective disclosure. But that's not what the court said. So we live with that, at least here in the Sixth Circuit, and it's not entirely different in a number of other circuits. There's really nothing that you can do. If we're going to have selective waiver, it's going to have to come through something like Proposed Evidence Rule 502. But that becomes an issue, too, because it'll be interesting to see the comments on it, and I'm not certain how a federal rule of evidence can work, although it says it would, can work to control what happens in state courts and state rules of evidence. But that appears to be the goal, and that appears to be an interesting challenge that will have to be debated, because the federal rule would extend beyond a particular case and would extend to state courts as well, because there would be obviously an issue, even though the federal rule was available, if it were not also available in every state court, you would have a horrible dilemma and would really have accomplished nothing. So, did you have a comment on that, Richard? I noticed you was...
Yes, I was going to say that the original version of 502 had a provision which would have preempted state law on the issue of whether the selective waiver doctrine should apply. The newest version that came out on August 10th leaves that issue to the states to determine.
Well, that really adds to the dilemma here, that because how is that going to shake out? I mean, state bars are very parochial about some of these things, and so that really the issue is still very much up in the air then.
I think the advantage of even a provision that doesn't address what happens before the state courts takes us a long ways, because most of the shareholder actions where these internal reports are being sought are in the federal courts. So maybe you're 80% there, but you still got some exposure, and that's still better than nothing.
Well, that's true, but we went through that cycle with Private Securities Litigation Reform Act and the migration of courts of cases to state court, which then led to SLUSA, and now we're still going back and forth on all of that and what is preempted. So there are a lot of those cases that are still being brought in state courts under state and common law theories, and they are viable. So that's obviously going to have to happen somewhere, because otherwise there is nothing you can do. It's an all or nothing proposition. You either waive it or you don't, and there are a lot of encouragements to waive it. What I started off with in the comment about the incentive to waive it in response to potential SEC enforcement action, but every day this is the dilemma that we face.
A different perspective. I'm a native of Danbury, Connecticut, home of America's greatest composer, Charles Ives. And so pursuing the musical metaphor, I think Jerry Presti was largely in tune with Richard Humes, except for a few jarring accidental notes. But Ives, one of Ives' most famous compositions, was inspired by his experience one 4th of July when he heard 3 different marching bands heading for the town green, and they're all playing different songs. I think with Bob, we are hearing a different melody here than the one that Richard initially gave us. Now, Richard, before I ask for questions from others, you responded to 1 or 2 points that Bob made, but I want to give you an opportunity to respond to anything else the other commentators have said so far.
Sure, I appreciate that. I really think that the comments from Bob and Geralyn have been very thoughtful, so I don't want to pick any fights at this point, but I would like to share just a couple of observations that people might find interesting. I have a great deal of sympathy with the concerns that Jerry raised about compliance with 404, because it's probably not widely known, but the commission is now audited by GAO. And so we have to certify our own internal controls. I'm personally involved in the process because just about all the defensive litigation against the commission, the claims against the commission, known or unknown, go through me. So I'm responsible for the legal rep letter. So I don't know whether that makes you feel better, but there was concern expressed about the fact that companies and officers might be reluctant to get legal advice on sensitive matters because that advice might end up being shared with the commission pursuant to a confidentiality agreement. But in the amicus briefs that we have filed on this issue, we've taken pains to point out that we're not trying to get contemporaneous legal advice. So if you're riding with your chairman and he asks a question, you give the advice. That's not what we're really seeking. We're looking for the reports prepared by retained counsel after the company has discovered that it has a problem. And I think most of those are being prepared with an eye towards providing them to the SEC. If you go to any of these programs on how to gear up to defend an SEC enforcement action, one of the first pieces of advice they give you is go hire outside counsel to do an internal report so you can give it to the commission, which I guess allows us to segue to one of the points that Rob made about the erosion of the attorney-client privilege. I just think that the company can make the judgment that it's in its best interest, whether it's current management or management that is under investigation, ousted management or management that is under investigation, that the entity's interest should prevail over those of individual officers, and it can certainly make the judgment in appropriate cases that disclosing these internal reports prepared by retained counsel is in the best interest of the entities. There was a reference to the Steinhardt case, which was one of the seminal cases on this issue, and I wanted to distinguish that between the current cases that we're participating as amicus and Steinhardt, which we also filed an amicus brief in that case. And in that case, we argued that there should be a waiver found, because in that case, we were talking about a well submission, which is an adversary piece that a company will send to the agency trying to convince it not to bring an action. And since it's prepared with the goal of providing it to the commission to convince the commission to do something, we don't need protection for that kind of a document. In contrast, the reports that are being prepared by retained counsel, at least at the inception, those were being prepared for independent corporate purposes. I just think it evolved into a practice where companies said, gosh, companies that are providing these are getting better treatment for the SEC, and the bar adopts the practice of let's prepare these for the SEC. I think that's it.
You know, on that point, Richard, I mean no criticism of that. It's simply a fact of life. And it has been, it's the result of a process that has been the carrot and the stick, and now it is recognized, and this is just, in a sense, what you do.
But, you know, companies must be getting something out of it, because they're doing it in the face of case law that certainly is tilted against recognizing these. So there must be something going on. I'm not involved in conversations between lawyers and company officials, but there must be some dynamic in that process that is prompting companies to make the decision, let's turn these reports over to the SEC.
And don't be worried that you're going to also have to turn them over to plaintiff's counsel in 4 or 5 cases that have been brought against you by shareholders or derivative cases.
Okay, yes, Jeff.
I think anyone would commend the SEC for its enhanced enforcement efforts to protect markets and prevent fraud. But what assurance can you give lawyers and clients that the SEC is not going to abuse the authority, other than the fact that I see you and I trust you, and I think the people there now are great, but they may not be there forever. And I worry that under 102E, you know, there's tremendous power. So imagine a lawyer who's been representing a client or doing securities representation for 30 years, and his or her work is their lifeblood. And now there's an SEC investigation, and there's a subpoena for documents, and the attorney has a colorable claim, let's say, of attorney-client privilege, but also knows that the SEC asserts the right to sanction the attorney and bar that person from practice in front of the attorney for years for wrongfully withholding a document demand by the SEC. That's going to put that attorney in a tremendously difficult situation, isn't it? So what kind of assurance can you give us that the SEC will not overstep the appropriate bounds of its authority in this area?
Just to add to the question, Richard, to make things a little harder for you, I don't know if Jeffrey had this at all in mind, but there's a fairly recent 102E decision in Ray Ira Weiss. As I think Richard Humes had said before, under 102E, the Commission had only in the past gone after situations where there were allegations and findings of intentional misconduct. In this proceeding, the Commission reversed the findings of the administrative law judge and found that the lawyer had violated Rule 102E, saying that his conduct was at least negligent, but never saying that it indeed was worse than negligence. So on top of what Jeffrey has said, there's also the concern that now the Commission has changed its view, and that merely negligent misconduct will violate 102E.
I think I'd like to break those questions up into parts. I think the first part is, how will those of us in the General Counsel's office approach these investigations? And I was trying to make the point in my initial presentation that we are sensitive to the effects that our inquiries can have on someone's practice. and their livelihood. And we are not out to discipline attorneys for innocent errors in judgment. But the cases that we now have, at least in my estimation, are sufficiently serious that they require us to look at this conduct. I think people should be able to take some comfort in the fact that before any proceeding can be brought, not only would the lawyer whose conduct is being examined have the opportunity to provide a well submission, they might convince us that notwithstanding what we think we found, that there are either factual problems with our case or that there are good legal and policy reasons for us not to bring a case. But it seems to me that if an attorney is handling a document production, let's say, and the client gives him the documents, and for some reason he intentionally decides, well, you know, some of these documents would really incriminate my client, I think I'll just take them out even and not produce them to the SEC, even though they're clearly called for by the subpoena, and they're not privileged, and I'm not going to put them on a privilege log. Or if you have someone saying to a client, I think that you ought to change your testimony before you testify in this proceeding because your testimony is going to get the company in trouble. I want you to change it in a way that's not accurate. And I think if you have those kinds of situations, then they demand that someone take a look at that conduct. Now, at the commission level, the commission would have to approve the institution of any proceedings. At this point, despite the formulation used in the Weiss case, I don't think the commission has committed itself to going after negligent violations. It hasn't decided that issue. And so it remains to be seen whether they will require some form of intent or recklessness or whether they would be satisfied with negligence.
Can I just ask one quick follow-up? So the situation where the lawyer representing a client has a colorable claim of privilege in response to an SEC document subpoena, that lawyer then hears from the SEC lawyer, well, you know, we've got 102E on the books, and we think your position is unreasonable. That's going to put that lawyer in a tremendous difficulty, isn't it? Because the lawyer says, I can zealously represent my client by resisting this document request, even though I know it may not be right. It's colorable. I think I have a claim, but there are lots of cases against me. But my obligation normally as a lawyer is to act with zeal to represent the client in present the best possible case for my client. But now the lawyer is thinking, gee, if I do that, the SEC might have a different view of it, and they might think that I'm deliberately obstructing an SEC investigation, and they may bring an action against me, and I may lose my license in front of the SEC for 3 years. Well, the lawyer's going to have a really hard time concluding that she or he ought to go with the client in that situation.
Well, I would be disappointed if an enforcement attorney threatened a 102E proceeding in the situation that you just described. Because if the lawyer has a good faith basis for withholding documents under claim of privilege, then the real remedy is for the enforcement attorney to bring a subpoena enforcement action, have a judicial test of that claim, not to threaten a 102E proceeding. But that's why the authority rests with the General Counsel's office. So you have this uncoupling of the enforcement responsibilities from the 102E responsibilities.
Right. Well, we could certainly continue. This has been like I guess a jazz performance that involves improvisation. And there is no natural end to it, except that in this particular case we have the clock to pay attention to, and I do want to get the second session started at 10:45 as scheduled. So I will wind this up now. Unfortunately, it would be fun to pursue it, but we need to wind it up so we can keep on schedule. But I think it was an excellent session, and thank you all.